These FAQs on the issue of the governor's pardon and commutation powers. So, do the federal and state chief executives both have pardon power? Yes. Both the US president and California's governor have the power to pardon criminal offenders. Where's the president's pardon power found? That is contained in Article 2, Section 2, Clause 1 of the United States Constitution, and it provides that the president shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Where is the governor's pardon power found? It's in Article 5, Section 8, Subdivision A of the California Constitution. Are the federal and state powers granted the same? The president's pardon power grants a criminal offender relief from any punishment from his or her conviction of a crime. The governor's pardon power is analogous. What is a commutation? It's a reduction in punishment. What's a pardon? It's the remission of guilt and basically relief from the legal consequences of the crimes committed. What is a reprieve? It's a temporary suspension of a sentence. Why is the governor's pardon power discretionary? Section 8A of Article 5 of the California Constitution provides the governor with the power to grant reprieves, pardons, and commutations, except in the case of an impeachment, which is similar to the federal Constitution's limit on the president. This authority is discretionary because the governor's power is on conditions the governor deems proper. When is the power granted to the governor? The power to grant a reprieve, pardon, or commutation occurs after an offender has been sentenced. This power is also subject to application procedures that are provided by statute adopted by the legislature. What is the role of the legislature? The legislature has imposed certain procedures for applying. However, granting a reprieve, pardon, or commutation is entirely in the discretion of the governor, without a role for the legislative branch of state government. What records must the governor maintain? Under Government Code Section 12030, the governor is required to keep a register, which includes all applications for pardon or commutation of any sentence. Must the governor disclose any official actions under this constitutional power when the governor exercises it? Yes. The state constitution, in fact, requires the governor to report to the legislature on every reprieve, pardon, or commutation the governor has granted. Now, what type of information is the governor required to disclose? In the report to the legislature, the governor is required to state the pertinent facts and the reasons for granting the reprieve, pardon, or commutation. Is there any obligation on other constitutional officers? Yes, pursuant to Government Code Section 12162, the Secretary of State is required to keep a register and attest to the official acts of the governor, including any pardons that the governor has issued. Is there any limit on the governor's pardon power? There is one constitutional limitation, and that is the governor may not grant a pardon or commutation to a person who has twice been convicted of a felony, except on recommendation of a majority, which would be 4 justices, of the California Supreme Court. What is required of the Supreme Court? The High Court acts upon an application submitted by the governor, and the California Supreme Court usually approves these gubernatorial requests, but they did reject a few in the past couple of years. How have California courts viewed the governor's pardon and commutation power? Basically, the courts in the state have said that the governor's clemency power is exclusive and that the legislature has no power to grant a reprieve, pardon, and commutation. They've described executive clemency as an ad hoc act of grace that may be granted for any reason without reference to any standard. Consistent with our state's separation of powers doctrine, pardon and commutation decisions have not traditionally been the business of courts and are rarely, if ever, appropriate subjects for judicial review. The Court of Appeal in Santos versus Brown in 2015 described it in that